Yes, Mr. Herbert.
Lords and Lady, before the short adjournment, I was addressing the court on section 404F, subsection 7, and I addressed the A limb
Yes.
in relation to the proposition that it was effectively entirely OTOs on an offence case. But we also raised the same question in relation to the B limb, the 404B,
Yes.
as to whether there is anything that is being done by 404F7 in relation to subsection B that couldn't have been done under section 55L in any event. It's important to have well in mind that section 404F7 is a power which relates to, conditions the power to vary the permission or authorization of the firm. That's its ambit. That's what it's connected with. If the FCA is exercised, obviously it operates in conjunction with 55L, which is a power that permits the permission or authorization of the firm to be varied. If one then turns to section 404B, I have to say that it caused in me a certain amount of head scratching as to what that variation of permission could actually achieve. If one looks at the main substantive parts of section 404B on page 179 in tab 4 of the First Authorities bundle, one sees that the first thing it does is in subsection 1B, if the consumer makes a complaint, and then B, at the time the complaint is made, the subject matter of the complaint falls to be dealt with under a consumer redress scheme, the way in which the complaint is to be determined by the Ombudsman is to be, as mentioned in subsection 4, and that is effectively saying, you, Ombudsman, shall determine the complaint according to how it should be dealt with under the consumer redress scheme. So the same consumer redress standards apply. That's the first thing it does. It tells the Ombudsman you should follow the scheme. Now, first question is, how does a variation of permission on the firm have any impact on the Ombudsman? Next, the same point occurs in relation to 2. If a consumer is not satisfied with the determination made by a relevant firm under a consumer redress scheme, the consumer may, in respect of that determination or failure, make a complaint under the Ombudsman scheme. And you'll see in that connection, the third point in subsection 11, the compulsory scheme of the Ombudsman, the compulsory jurisdiction of the Ombudsman scheme is to include the jurisdiction resulting from this section. And that was a necessary provision because there's lots of authority. It's not in the bundle, but there's lots of clear authority that a complaint about how a firm's operated a complaint scheme isn't a provision of a financial service that can go to the Ombudsman normally at all. Lots of people, particularly in the small business structured interest rate product context, who didn't like the determination and tried to go off to the Ombudsman and got sent away. So what section 404B11 does is to actually extend the compulsory jurisdiction of the Ombudsman scheme so they can actually determine such dissatisfied complaints. How, I ask again, can that be achieved by a variation of the firm's permission?
Isn't that precisely why you need little b in 404F7, which says you can include such a provision?
But my objection, Lord, is rather more fundamental. It's no good saying you can include it. Even if you do say something in the varied permission, it can't have any impact on the Ombudsman's compulsory jurisdiction. The Ombudsman's jurisdiction can't be constituted by a variation of the firm's permission.
Sorry.
Why is 404.7b not statutory authority for extending the Ombudsman's compulsory jurisdiction to determining whether a single firm redress scheme made by way of varying a permission is something that the consumer can take to the Ombudsman?
Well, it has to work somehow. 404B has to be authority for that. My question is, the point I'm raising is I'm not sure it operates via 404F7.
Why not? Isn't that what 404F7 says? It says the FCA can include provision corresponding to section 404B. So why can't it include a provision in the variation of permission scheme saying if you are required under this scheme to pay compensation, redress, whatever, and the consumer is dissatisfied, the consumer may take it to the ombudsman.
Well, Lord, the issue I'm raising, maybe it's not the biggest in the world, but the issue I'm raising is that it's very difficult to see how a variation of permission, which tells the firm what it can and can't do, can have any impact on the ombudsman.
So
The ombudsman said,
is 7B on your case then, OTS?
well, not entirely. I would apprehend that in a multi-purpose scheme, 404B will be operated by, as it were, being included in rules, no doubt. Now, I venture at least to suggest that 404B, even in a single company scheme, can't operate to change the ombudsman's jurisdiction by changing the firm's permission. There may be some separate need for 404B, and there are aspects of 404B that could be catered for in varied rules. For example, there's even a bit of Conrad.
Sorry, are you sticking with 404F7B? Are you saying that cannot have the effect that the FCA says, because it can't change the ombudsman's jurisdiction? Is that what you're
Lord,
saying?
yes, I'm saying that much of the work of 404B can't be done through a variation of permission.
But then you're saying that this provision is OTOs. You're saying that 7B, 404F7B, doesn't achieve what the FCA says it sets out to achieve.
Lady, yes, I'm saying that anything
even though that's what it purports to do.
anything you can do in relation to 404B, you could equally well do by 55L as you could by 404.7B. So, for example,
But go back to my question.
yes.
What does 7B
So
achieve?
Conrad, for example, suggests that one obligation that one might want to include in varied rules is to assist the FOS in identifying relevant cases. Firms may be required to draw the scheme to the attention of FOS in any individual cases as referred to it. So you could clearly amend the firm's permission to say, look, you must tell FOS about all these cases to ensure a proper application, to ensure they're not missed and dealt with on a different basis.
And how is that a provision that corresponds to section 404B?
Well, my lord, it relates to 404B. Whether it doesn't, it certainly doesn't correspond to any particular obligation under it. Lord, it may be that the point I'm raising is it's a structural problem to which I don't see an immediate answer.
No. Well, it rather undermines the force of your argument that the case against you renders 7 OTS if, on your construction, part of it is OTS.
Yeah, Lord,
It's not impossible that you're both right. One does find provisions in statutes that don't have any obvious effects.
Well,
but
they're two entirely different questions, which is A and B.
Yes.
Under B, it is difficult to see the mechanism under 404B. What one could speculate is that the position, as it were, alerting the FCA that it can exercise the 404B power in relation to a scheme, in relation to a 404 F7 scheme. So it's effectively, it may not be done by the variation of permission. I certainly don't say that you can't use the ombudsman in a single company scheme. That's not my suggestion. It's been used. But it just seemed to me that you need some separate legislative basis that wasn't section 404 F7 to achieve the principal aims of section 404B.
And that's not something that the FCA itself could do, or could it? The scheme is part statutory and part governed by handbook rules, isn't it?
It might well be that the FCA would have some residual power to make it well.
I mean, if the jurisdiction to bind the ombudsman in a single firm scheme doesn't come from
Yes.
F7B, where else could it come from?
Well, I haven't been able to identify a source. Well, in a multi-firm scheme, it would presumably be as part of the rules being made under 404,
Yes.
under 404A. And it may be that
And your general point is that the whole purpose of 404F7 is to bring a single firm scheme in line with a multi-firm scheme.
Well, yes, absolutely, and I'm sure, no doubt that in this respect as well. Hence the reference to 404B. There's not clearly not intended to be any difference of application. I'm certainly not suggesting that they're not being brought into line. It's more just a question of mechanics, and because this is really responding to an argument that 404 F7 is doing some work in introducing these rules, and I'm saying, well, I don't see how that's done. I don't see how a variation of permission extends the FOS's jurisdiction.
Well, the answer is, if, as you contend, the intention is to put, at least in this respect, a single firm scheme on the same footing as a multi-firm scheme, so far as the Ombudsman's concerned, that's how you interpret 7B in terms of conferring the power on the FCA to achieve that.
Well, yeah, it may be that the power is separately exercisable. Maybe the answer.
You said that 404B and a multi-firm scheme could be included in the rules. Is that necessary? Doesn't it just apply if there is a multi-firm scheme? Doesn't 404B just extend the Ombudsman's jurisdiction anyway?
And Lord, that may be right, and the answer might be then that a single company scheme comes within the meaning of a consumer redress scheme, so that it happens also with a single company scheme.
Well,
I think that's difficult
I think that's quite difficult.
because F7 is concerns which with schemes which correspond to or are similar to, but are not a consumer redress scheme.
But we would suggest that single company scheme is potentially capable of amounting to a consumer redress scheme for the purpose of section 404B. The scheme is defined in 404B. Yes. So, Lord, as a consumer redress scheme is defined, page 174, section 104.4. Consumer redress scheme is a scheme under which a firm is required to take one or more of the following steps in relation to the activity. And then you'll see the steps are set out between 5 and end of 7. And 7 includes, if the firm determines that the failure has caused or may cause loss or damage to consumers, it must then make the redress to the consumers. Indeed, the one above that may be relevant, determine what redress should be in respect to the failure. Now, I do submit that for the purposes of these sections at least, a single company scheme, even the present one, which does fall within the definition of a consumer redress scheme on those terms, between subsection 4 and subsection 7 definition. Well, if that is right, rewinding, then it may be that my Lord Justice Nugee's point is the correct answer to my question as to the jurisdiction, which is that 404B is effectively switched on as a scheme.
Can I ask a slightly different question? The way I read 404B, effectively where it applies, tells the Ombudsman how to deal with the relevant complaint.
That's one part of it, Melissa.
Yes. Can you explain for the uninitiated what the reference to compulsory jurisdiction in subsection 11 is? That I read the whole thing as rather suggesting that it's got jurisdiction anyway, but it's compulsory jurisdiction sounds different.
The Ombudsman has effectively two jurisdictions, a compulsory jurisdiction and a voluntary jurisdiction. Compulsory jurisdiction, as it sounds, is where the firm has no choice but to comply with it. Separately, a firm can agree to confer jurisdiction.
So the compulsory refers to compulsory as far as the firm is concerned.
As far as the firm is concerned.
Thank you.
And so the compulsory jurisdiction can be extended by subsection 11.
Thank you.
Lord,
But
if-
just following through
Yes.
where your rewind is. So, if it's a single firm scheme is a consumer redress scheme, and 404B therefore applies automatically. What content do you give to 7B?
Lord, I would submit that it's effectively clarificatory, because even if that provision didn't exist, if the scheme amounted to a consumer redress scheme by way of a variation under whether it's 55L or 55L with on my own friend's case or with 404 F7 on my case, the turning on of section 404B would occur by virtue of its definition as a consumer redress scheme. So the provision is not a necessary provision.
So it has no content.
Except insofar as potentially it allows the variation of permission to do things that are an adjunct to 404B.
Thank you.
Well, I raise that with a question mark rather than because it is central to as a building block of the overall argument. It seems to be a structural issue which I thought was right to put before the court. Principal case is that A is OTOs, B may be, but it may be on both cases as you I can see on one analysis it does so. But that's where one gets on the point. Well, I'm then going to move quite swiftly through parts of the argument that are either clear on my skeleton or I've already addressed. Further reasons why we say that our interpretation of the two interlocking sections is the preferable one. The fourth, which we set out in our skeleton, is that an unrestricted ambit of 55L would be very surprising, given that it occurs in FSMA in the context of a variety of carefully tailored means of permitting redress for consumers. Some self-help by consumers, like an action for damages, some with the authorities' assistance, restitution, multi-schemes, and some with an external agency such as the FOS. I'm not going to go through all those powers again because they're all set out clearly in the argument. We accept that not every single one of the four conditions of actionability applies to each. The point is not that every step is required in every case. It is that there is a carefully tailored scheme, all of which have some of the four conditions and some of which have all of them. And that it would be very surprising if ever since 2000 Parliament had sub silentio included a power far greater reach than any of them.
But there's a logically anterior presumption in that proposition, which is that the FCA only has power to impose by way of a condition something which it would also have power to impose by way of one of the four forms of redress. That is the presumption.
I'm afraid
the assumption which underlies this point,
yes,
is that there could only be a power to impose as a condition of authorization, permission, whether originally or by variation or by new requirement, something which there was also a power to impose by way of redress in one of the four forms you're identifying. Because otherwise your argument assumes what it sets out to prove. And is that premise correct? If it's the case that by way of grant of permission, the FCA is entitled to say, you must pay a debt you owe to X, or you must pay something to X as a condition, it may be able to do so without that being a form of redress it could order.
Well, I addressed the point this morning that under the Act as it existed until 2010, it may be the case, as your Lordship put to me, that one can require a pre-existing issue which arises at the time of permission to be addressed. But I also made the point that that argument would not open the way imposing a redress order in respect of conduct as an authorised person, because it wouldn't be something which could be granted at the stage of permission, because it's not an issue which is capable of arising at that stage. That goes to create at the very least a substantial uncertainty as to the reach of the power. It may or may not theoretically have existed, but it's a power that would not have been, we say, until 2010, when 404 1F7 was enacted. We say that there was no power would have survived.
Take my county court debt, for example, which has been outstanding for a year, as it incurred at a time when the person wasn't an authorised person.
Yes.
Would there be one of the 4 forms of redress powers that would enable the FCA to say you must pay that?
No, my lord, because the county court debts are owed to some fund wouldn't be anything to do with financial services.
Right. And therefore, if it were the case, which you didn't concede but thought there might be some force in, that is something which could be imposed by way of a condition of authorisation, then that shows that it's a false logical step to say that the imposition of conditions or requirements to permission can only be given in cases where there would be a power to grant redress in one of the 4 forms. That's the point. That's the point I'm on.
And that was not the submission I was trying to make. I see. I see.
It's my fault. I didn't express it very clearly, but that's the point I'm on.
Probably my fault. You're not bringing it up. My submission was a much more general one, and it was coming back to looking at whether it is likely that Parliament gave the authority a general power in the interests of consumers, advancing its consumer protection objective, to effectively do what it liked in ordering redress, putting it in a prejudicial way.
Well,
is that likely calibrated against all the other powers in the Act and the multi-scheme? And I don't accept that assumes what I set out to prove. We're looking at the amplitude of the power, and which is contended for, which I submit is that there are very strong reasons not to construe the power as giving it that amplitude, because it would be so out of place by reference to all the other powers in the Act. The fact that technically one could or one could not derive some power to do something on varying permission relating to prior conduct, which we say would not include a redress scheme, I'm not sure goes to that argument, or certainly doesn't undermine it.
Right.
I mean, there are all sorts of different consumer protection powers. The most obvious one is stop taking new business. So there were all sorts of different consumer protection interests that one can advance by a variation of permission. I fully accept that. The most obvious is you're concerned about what a firm is doing. You require it to stop taking on new business because you're worried about its capital adequacy, or you're worried about what the business it's doing, or for all sorts of reasons.
But we're using redress here as a shorthand for requiring it to pay money.
Yes, which is indeed which is different. So that there's consumer protection, but we're talking about past conduct and redress and
it may be able to do that for some forms of redress which aren't within the form categories, pay the county court debt, but not, you say, at least not relevantly so for the purposes of your submission, because what we're looking at is something which looks like a market-wide.
I certainly wouldn't accept that the example your lordship's given me constitutes redress. I mean, requiring a firm to pay its debts as they fall due, whether it's a debt to the person who's built the offices or whatever the reason, may be something for capital adequacy reasons or for other reasons that conceivably could be included in a fresh permission application of pre-existing debt. That's very different from requiring a firm
from a Section 150 claim. Very different from a Section 150 claim, which is a claim for breach of statutory duty, which is one of your 4 forms of redress.
For breach of a recognised requirement of a switched on, as it were, or not switched off a requirement which amounts to a regulatory enforceable action. We've said it's a long way away.
Thank you.
Lords and Lady, then there were the legislative materials, which were relied on by the judge. I'm not going to go back over the substance of the white paper. Your Lordship's seen it, Lordship's seen it. It's in the judgment at paragraph 301 to 302 of the judgment. It's in our submissions, in our skeleton, paragraph 24. It was only ever a straw in the wind, we say, in undermining the case that the single company scheme went back to 2000 and emphasising the dual introduction of the multi and single company scheme together in 2010. A lot of dust has been thrown up as to whether it is clear enough in indicating that. We say it is, particularly in the second sentence, but mindful of the requirement that reliance on a Hansard extract has to be clear. I'm not going to push it further. The court can make up its own mind as to what they take from that. We do strongly rely on the two subsequent delegated enactments, which the tribunal relied on at paragraphs 304 to 306. They are, we say, admissible as persuasive authority. For what it's worth, and in view of the time, I'm not going to take the court to it unless it wishes, but there's an extract of Benyon on this point in the authorities bundle at tab 90, page 2513, relying on Lord Lowry's speech in Hanlon. But we submit that given that the delegated enactments are enactments under FSMA, and that FSMA does indeed have a power permitting it to amend primary legislation through delegated enactments, which is one of the conditions that Benyon refers to. And just for the court to note, that is paragraph 25 of Schedule 2 of FSMA, 25(1)(f).
Sorry, these particular SIs aren't amending primary law.
They're not. But Benyon looks at one of the conditions generally as being whether they have the capacity, the delegated declarations are made under an instrument where there is the capacity to amend primary legislation, because that is then thought to be relevant to whether the extent to which they are relevant. They're more persuasive if they are contemporaneous, and these are subsequent, so that's a factor which the court will have regard to. But we say that both of them, which are set out in the judgment at paragraph, first of all, Article 58 is in the judgment at paragraph 304, and then Article 82(12) in paragraph 306. Both of those refer on their face to requirements imposed by the authority. They disjunctively refer to 55L and 404F7 as being powers. So we do rely on those. Then there is the authority's own guidance, and that is important and applies from early after the Act itself was amended in 2010, right up until the present day, in two separate forms. You've seen both the interim guidance set out in the judgment and then the current guidance in Conrad. Again, we say that is clearly admissible. There's one paragraph in the Chief Constable of Cumbrian Right in the Supreme in a judgment of Mr. Justice Lloyd Jones, which was approved in the Supreme Court, which we say makes that good. I mean, FCA guidance is frequently referred to in cases involving FCA in construction of provisions under FSMA, and we say that is right. It may be that I should just take you to that one paragraph if there's any lingering doubt about admissibility. It's supplementary bundle, tab 3, page 19. So it's the small supplemental bundle that we filed. Chief Constable Cumbrian White's tab 3, and the relevant passage is at paragraph 24, paragraph 17. It is, of course, for the courts, not the executive, to interpret legislation. In general, official statements by government departments administering an act.
So I'm not with you. Did you say 24?
Yes, Lord, page 24.
Page 24, sorry.
Page 24, paragraph 17, my Lord, I apologise.
I'm with you now.
It's for the courts, not the executive, to interpret legislation. However, in general, official statements by government departments administering an act or by any other authority concerned with an act may be taken into account as persuasive authority on the legal meaning of provisions. It's the principal statement in Benyon. In the present case, we're concerned with guidance published by the Home Office, which is the government department which has responsibility for the enactment and operation of the legislation in question. In any given case, it may be helpful for the court to refer to the guidance in the interpretation of the legislation. It may be of some persuasive authority. However, to my mind, that's the limits of the influence. It doesn't differ in this regard from a statement by an academic author or textbook. Doesn't enjoy any particular legal status. There seems to me to be no satisfactory basis for the submission that it gives rise to a presumption that the views are correct and should be rejected only for good reason. And as we said, that was, I'm not to it. That was cited with approval by the Supreme Court in Gray's Timber, which is in Supplemental Authority Bundle 4 at page 50 per Lord Hope. Now, my Lord, here the guidance is extensively set out in the tribunal from paragraphs 308 onwards. And again, in view of the time, I'm not going to take you through the details, some of which you were shown and engaged indeed with my learned friend on. But it is notable that what one sees, first of all, that the first guidance shortly after the 2010 Act came into force, use of 404 F7 powers on single firms. The FCA, we say, from the passages set out under that paragraph, made it absolutely clear that they considered that this was a power under 404 F7. And certainly the reference to it cannot be explained, for example, on the basis of the FOS might, on occasional cases, be used to switch on one part of it, if that was the case. And I leave it to the court to see the extract set out. And similarly, we say in relation to the guidance which then was promulgated following consultation, full consultation in Conway. Once again, paragraph 309, the tribunal sets out the most relevant passages. It says in terms that section 404 F7 empowers the FCA to require the firm to establish and operate a scheme, and so on and so forth. It's not in ambiguous terms in any way. And there's no mention of a separate 55L power at all in this context in Conrad. And the tribunal furthermore noted paragraph 310, similar statements also made in other sections of the authorities handbook. I'm not going to multiply examples. And even, as was pointed out to my learned friend, in the supervisory notice in this very case, as was pointed out, sub 11, page 44, I'm not going to go back to it, but even that the instrument itself cited section 404 F7 as a relevant statutory provision without which there's no good explanation, and learned friend accepted was not an apposite on his case, not an apposite citation. My Lord and Lady, I do need to shortly address section 55N, which I haven't yet addressed in my submissions, which we say does present a little bit of a puzzle on either side's approach to the provision, to the variation provision. But we do submit that it fits far better with our interpretation of the legislation than the authorities. My Lord, at this point, the historical chronology is crucial, because section 55N was enacted by way of the 2012 Act, some 2 years after the enactment, therefore, of section 404 F7 in 2010. So whichever party's construction of section 55L stroke 404 F7 is correct, therefore, the authority already had, by the time of the enactment of section 55N, already had a power to impose a single company redress scheme, and section 55N comes on top of that. Either pursuant to 55L, it had the power, or the two read together. Thus, the authority's emphasis in its skeleton paragraphs 23 to 25 on section 55N as a source of the power to impose a single firm redress scheme is misplaced, because it's common ground that the power to impose such a scheme already existed prior to the enactment of section 55N. Whether from 2010 or 2000, that's the only argument. So that fact, of course, then does raise a question as to the purpose of section 55N if the power already existed.
I think you mean here specifically 55N5.
I do. I
rather than the
55N
other
is
parts of
essential.
55N. Yes.
Well, I think that's right. It's 55N5. We say that it's what is clear is that if the power under 55L were as wide as the learned friend contends for, then no purpose would have been served by 55N at all. It would add nothing. The authority could already do under 55L have imposed any requirement of the type articulated in 55N if it deemed it desirable to do so. You can't see any basis of learned friend's case of an unlimited wide power that there's anything further that they could have done. And the authority's answer to that is, of it being OTOs, is that 55N was merely to clarify the scope of a pre-existing power. That's what it said in their scope in paragraph 25. But that's contradicted by the explanatory notes to section to FSMA 2012. Can I just take you to paragraph 206 of those notes? It's the first authority's bundle, saying in the same bundle, tab 9, page 264. That at least suggests that it was doing something new. One looks at paragraph 206 on page 264. One sees right at the end, the last 4 lines, subsection 5, and that's, as your Lordship says, is the really crucial section, enables a requirement to refer to the past conduct of the person concerned. This could be used by either regulator to require an authorised person to carry out a review of its past conduct, for example, to identify customers who have been treated unfairly. Now, we don't see any reason why that couldn't have been done on my learned friend's very wide interpretation of the powers existing under 55L. But we do say, and the tribunal held, that it does make some sense on our interpretation of section 55L constrained by section 404F7 as being, as it were, the limits of the redress power. Because what can then be seen is that the section was intended to clarify the authority's power to impose remedial action as well as redress, intended to devote activities such as a review of past business, actually cited, activities which are broader than those comprehended in section 55L read with 407F. In other words, for example, in the first place, you could do review even if it wasn't a redress case. You weren't actually imposing a redress scheme, but you just wanted a firm to do a review, for example.
So,
lead to a redress
on
scheme.
your case, you had, in one sense, a greater power as regards past actions, which is to require redress, albeit within the framework of 404 and 404A. But you couldn't have required a review.
Lady,
Between
yes.
2010 and 2012.
Lady, yes. Yes. So in a sense, well, it says they have the greater power. 55L trumps everything, and it is a power that could require absolutely everything. But yes, if your ladyship by greater meant greater than before, then precisely yes.
Well, greater in the sense of more
than we have.
extensive,
Yes.
more
Yes.
extensive.
More
Because
extensive
generally requiring someone to pay might be thought to be potentially more onerous.
Yes.
Than
Yes, I see.
requiring
I see.
a review.
Yes, I see. Yeah, absolutely, believe me. That's precisely what we say. And you can see the tribunal accepted that explanation of 55N at paragraph 315 of the decision, and it rightly noted that there is indeed a familiar distinction between remedial action and redress, and relying on the authority's own handbook and guidance. Now, Lord, my lady, we do say that remains the best explanation of what is on a puzzle for either side, for both sides to explain otherwise. That explains why the explanatory notes contemplated and why, just as looked at as a piece of legislation, section 55N could be regarded as having some independent life and be doing some additional work. which makes sense on our explanation. It doesn't make sense on my learned friend's conception of the variation, the width of the variation power. So that, milady, that addresses 55N. I then undertook to address the 4 conditions required by a single company redress power, but I apprehend that I have effectively dealt with that whole section, first of all in my exposition of the multi-firm power, where I set out how under the multi-firm power the 4 conditions could be derived from section 404A, and then in response to questions from the bench in relation to how those sections operated. We say that there is no difficulty in deriving each of the 4 conditions from from the interlocking sections in 404A. Loss, damage, causation clearly embedded, because the rules can only require a firm to determine whether a failure has caused loss or damage to consumers, if the court would have had regard to those matters. And actionability and duty, we say, as I've already said to the court, derive from the interlocking sections 404A3 and 404A1C. And you read those together, and it is quite clear that the rules, therefore, or the matters to be included in the variation of permission, if it's measured on a single company basis, rules for multi-company, provisions for single company scheme, that they cannot require the assessment of evidence or in limb 1 or findings of breach in circumstances where it wouldn't be required according to a multi-firm, wouldn't be required in court. I was conscious I was paraphrasing as I said that. So one is assessing evidence of a failure to comply with a requirement, and 2 is determining whether such a failure has caused or may cause loss or damage to consumers. Such a failure relates back to failure to comply with a requirement. And both of those act as an integrated whole in preventing rules requiring a firm to assess evidence or to determine a failure in relation to a requirement which is not actionable and which isn't a requirement which actually provides a duty and therefore breach of duty to those whom the scheme intends to redress. And then yes, and then finally on actionability, in any event we would press in aid Conred 1.3.16 and 1.3.17. I'm not going to go back to them, especially if you have the time. For the court's note, it's A2, tab 23, page 411. The court saw them, and these are referred to by the tribunal at paragraph 394, right at the end of the at the end of the decision of the tribunal. But in terms 1.3.16 acknowledges the requirement of actionability. We say that it clearly describes, it is clearly talking of all schemes at that point, multi-firm and single-firm schemes, and can't be explained on the basis that it's only talking about multi-firm schemes. But I leave that, I'm not going to need to address those provisions further. So, Lord, it's a bit of a gallop. I've reached the stage where I was going to hand over to Mr. Burgess, but clearly he can have a fresh start in the morning with
Yes.
the piece of the court.
Yes. Thank you. 10 o'clock.
All rise, people.